Okay, I'll wait for people to join. All right, I see some people are joining the Instagram. Hi, everyone. This is Natalia. I'm an immigration attorney with McKenzie Law Group. We practice exclusively immigration law here in Chicago. We also have an office in Dublin, Ireland. Our managing partners and our founding partner is originally from Ireland. So that's something to let you know about our law firm. We do practice immigration law exclusively. We do immigration defense in immigration courts, family immigration cases, naturalization, a lot of employment immigration cases. So if you need immigration help, always feel free to contact our office. We will be happy to help you out, and we're just a phone call away. I will allow some time for people to join. We took a break from First Fridays this summer, and we're back with First Fridays now in August. So next month, somebody else from our team, some other attorney, will do the First Friday, and we will keep doing this consistently, hopefully. But we just had a short summer break from First Fridays. We have a lot of news to share today with you. A lot of things happened over the course of the past 2 months, and I'm going to walk you through the immigration updates. We'll answer some of the immigration questions that we received, and we'll most definitely check your questions that you may want to submit online. So feel free to submit your questions online. I will start with the immigration updates. So let's start with the good news. So we have some really good news to share today. The state of Illinois has passed 2 laws. So the Governor Pritzker has been amazing in terms of passing immigration law, in terms of passing the laws that relate to foreign nationals within the state of Illinois. So the very first piece of legislation that I wanted to share is that Illinois will now, starting from January 1st of 2024, will begin issuing driver's license to eligible applicants who are foreign nationals without proper immigration status in the US. Of course, people will need to show that they're able to drive vehicles. They will have to present some form of identification. And we're yet to see how the Department of State will outline the specific requirements for the driver. So this is great news. I know that some other states like Pennsylvania, like New York, been issuing driver's licenses to people, to foreign nationals who are here without lawful status under some circumstances. So finally, starting next year, Illinois will join those states and will issue driver's licenses to foreign nationals who are undocumented in the United States. The second legislation that was passed would allow, beginning January 1st of 2024, would allow non-citizens such as DACA status holders or lawful permanent residents to apply to become police officers in the state of Illinois. This is really great news. This is not a unique legislation. Actually, the state of California has something very similar. It's been in effect for some time already. So I'm glad that Illinois is joining in this effort as well. So people, obviously, the foreign nationals will need to be work authorized in the United States to become police officers and will have to have a permit to carry firearms. This legislation doesn't mean that undocumented immigrants will be able to become police officers. Non-citizens who are present here in the United States based on some status and have a work authorization in the US will be able to apply. So this news have been misinterpreted by some news outlets saying that Illinois would allow undocumented foreign nationals to become police officers. This is not true. This legislation is way more limited, and we're yet to see how this plays out. Another piece of good news that we wanted to share is that the second round of H-1B lottery has happened. So congratulations to all who were selected during the second round of the H-1B lottery. As we know, the first round went ahead and was completed at the beginning of this year. Then people who were selected were able to file their petitions, and then the USCIS has determined that there are more quotas available, so not all of them were used this year. There are, just to remind you, 65,000 regular H-1B visas that can be issued this year, and 20,000 H-1B visas for those with advanced degrees, such as master's degree, for example. So at the end of July 2023, the USCIS has announced that an additional round of an H-1B lottery will take place, and we are glad that happened. We had several clients that were selected during the second round, and they will be able to file their petitions. So those who were selected during the second round of the H-1B lottery will be able to check on that and see what period of time was allowed for them to file the petitions. And once again, congratulations to those foreign nationals who were selected during the second round of the H-1B lottery. This is amazing news. As a former H-1B visa holder, I know what it means. So I'm very happy for you if you are the one who were selected. Another great piece of news is that the DHS announced that the new processing times have been updated for multiple forms that people file with the USCIS. So now if you go on the USCIS website, and if you would like to check on the processing times, you will be able to see the updated processing times. So it's always nice when the USCIS updates the processing times specific to certain applications or petitions, because we know if the processing times were updated recently, the processing times indicated in that schedule are definitely more or less accurate. Another practice alert we received this month was about the enforcement priorities. So ICE reinstated Mayorkas enforcement priorities in Doyle memo. So what it means: on June 23rd of 2023, the U.S. Supreme Court issued a favorable decision in one of its cases where Texas and Louisiana challenged the immigration priorities outlined in the DHS memos that went into effect in 2021. So when this challenge was brought to the federal court in 2022, those immigration priorities outlined in the 2021 memos were paused, and the Supreme Court finally ruled this summer that the enforcement priorities are actually valid, and that those memos are valid, and that the ICE officers, as well as us practitioners, can now again rely on those memos. So why is that important, and who will benefit from this? People who will benefit from this are mostly people who found themselves in removal proceedings in immigration court, or people who are currently in immigration detention. There is a way or multiple ways to argue with the government using these immigration priorities and these two memorandums issued in 2021 to allow the immigration court to issue a favorable decision or release a person from detention, from immigration detention. This is, of course, a legal question that if you think like these memorandums can be applicable to every case, definitely talk to an immigration lawyer because every case is different. And the way an immigration lawyer may be able to apply these memorandums can be different depending on what case you have. I personally have previously used these memos to get people out of immigration detention after people crossed the southern border and were kept in immigration detention. They hired our law firm, and I was able to argue in favor of those detained people and have them released from immigration detention, citing the two memos. So I'm very happy that the memos are back. This is definitely great news. Another great news that we've got is that the USCIS now allows to reschedule biometrics appointment online. So previously, to reschedule a biometrics appointment, people had to call the USCIS and ask to reschedule a biometrics appointment. It was not always easy to get hold of a live agent when people called the customer support service. So now this tool will be available online. If you have a biometrics appointment scheduled, and if you would like to reschedule your biometrics appointment, then you can definitely use this tool, but there are some limitations. So the USCIS is saying that people cannot use this tool if they rescheduled 2 or more times already. They cannot use this self-scheduling tool if they intend to use it within 12 hours of the appointment time, and if this appointment, the biometrics appointment, has already passed. So definitely to use this tool, self-rescheduling tool on the USCIS website, you need to do it timely and in advance. So there's a question what to do if the request to reschedule is untimely. Then an option is there's always an option to call the USCIS and try to get a hold of a live agent and reschedule the biometrics appointment. This is definitely harder to do. And if the request is untimely, then the USCIS may ask you for a good cause to reschedule such an appointment. And in its policy manual, the USCIS actually was so nice outlining the reasons that establish a good cause for rescheduling a biometrics appointment untimely. So it may be illness, it may be pre-planned travel, it may be significant life events such as wedding, funeral, or a graduation ceremony. It may be an inability to obtain transportation for the upcoming appointment, and so on. So definitely, if you are making an untimely request, consult with the USCIS website on what it considers to be a good cause for rescheduling. In terms of the Biden's new asylum policy, there is some news that we received from the federal judge in the Northern District of California. So what happened recently, the Biden administration has introduced new immigration policy in terms of asylum. Under that immigration policy, people had to pre-schedule their arrival time into the US. So they had to use the CBP One app to schedule an appointment with a CBP officer, or people had to have a humanitarian parole pre-approved in advance, or people had to apply for asylum in a third country that they crossed on their way to the United States. So those limitations definitely had a negative impact on a lot of asylum applicants. The CBP One platform did not really work well for many asylum applicants. Some people were unable to apply for asylum in third countries or did not know or could not apply for a humanitarian parole. So when these rules were introduced by the Biden administration, of course, there was a federal lawsuit to get rid of this rule as arbitrary and capricious, and the federal judge in the Northern District of California granted the plaintiff's motion for summary judgment and vacated the DHS rule that was limiting asylum. So now the Biden administration has 14 days to file an appeal, and I'm pretty sure the Biden administration will go ahead and file the appeal. We will see how this resolves within the next months. We will keep an eye on the developments in this particular case. There are some changes in ESTA rules designed for the citizens of Hungary. So DHS announced the reduction of ESTA travel authorization validity period from 2 years to 1 year for the citizens of Hungary. It also limits the validity of an ESTA for a single travel. So that is definitely a significant limitation that is now in effect. So if it affects you, just keep in mind that an ESTA will be starting August 1st, 2023, an ESTA for citizens of or nationals of Hungary will be limited to single use, and it will be issued only for 1 year. Let's move to other news. So the Form I-131, an application for a travel document, has been updated by the USCIS. A new form will be used starting September 12th. So be careful when you use this form because a new edition will be accepted and old editions will be denied. Form I-131 is widely used by different foreign nationals and different immigration status in the US. It can be used to apply for a refugee travel document. It can be used to apply for a DACA travel document to allow a DACA recipient to travel outside the US for certain reasons. It can be used by adjustment of status applicants to apply for a travel authorization called advanced parole. This is a form that is definitely widely used by foreign nationals. And very often foreign nationals decide to fill out this form, which is a pretty straightforward form, on their own. So please keep an eye on the edition of the form. Double check that all the pages are of the current edition, because otherwise the form may be denied and will be denied by the USCIS. To avoid the denial, just always check a specific page on the USCIS website related to the I-131 applications and check the edition date. We also received some news from CDC. So CDC has updated its COVID-related vaccination requirements for civil surgeons. We still have a COVID-19 vaccination requirement for, let's say, adjustment of status in the United States, to get an immigrant visa to come to the United States. But the guidelines were slightly amended by the CDC. So what are the amendments? So first of all, the applicant must receive 1 dose of COVID-19 vaccine. And if a dose is due at the time of the medical appointment for the medical exam form for the immigration purposes, then an additional dose is no longer required for the applicant to receive the medical exam form, as long as there is 1 dose, but a civil surgeon will make a note that the second dose has not been administered. And the applicants who have completed any approved primary COVID-19 series before the exam require no additional COVID-19 doses for immigration. There were no updates in terms of the boosters. So boosters are still not required for the medical exam, but please keep an eye on the updates from the CDC in terms of the boosters. we also received some news from ICE. So ICE enabled its online tool for the foreign nationals to go ahead and change their address online. So the foreign nationals can still call the ICE and still come for an in-person appointment to update on their address. But for a lot of people, having an online tool to do that, it's a huge improvement. And it's definitely great for us as immigration attorneys as well. The change of address tool is fully operational according to ICE as of this summer. So if you need to update your address, if you're a foreign national and ICE keeps track of your case and you know that you need to update the ICE with your address as you move, then you can use this online tool on the on the DHS ICE website. Um, this is a great update from the ICE. And I'm actually glad that our immigration system is improving and is becoming more modern as time goes by. All right, I think I covered all the news. And just a general reminder, the CBP no longer requires proof of vaccination for non-immigrant travelers. For example, if you're traveling on a B visa, then the CBP will not require proof of vaccination against COVID-19. This news came in this summer and allowed a lot of international travelers to finally come to the United States if they were not vaccinated against COVID-19. Wanted to update you on the events that we will be having at McKenzie. We have a webinar coming up on August 30th. So if you are on our mailing list, you probably received updates regarding an upcoming webinar that will be hosted by our managing partner, an amazing attorney, Fiona McKenzie. She will be talking about national interest waiver and EB-1A green cards. Those are self-sponsoring petitions that you can file if you qualify. So if you'd like to find out more about those specific cases, you can register for this webinar on our website. We also have a lot of new editorials and articles on our website. So please make sure you check our website. Fiona also has published a new op-ed in Crane's Chicago business about her venture capital fund. So you can definitely check on that. That's some amazing news that we wanted to share with you. And we have a couple of questions from our followers online. And let me check on those questions. They have all of them. So the very first question, I'm an asylee and I filed for adjustment of status, but I was confused by Form I-131. Do I apply for an advance parole or refugee travel document? I would say it's up to you as an asylee who is filing for an adjustment of status in the United States. As an asylee, you can definitely file for a refugee travel document. This document can be used for international travel, but we do not recommend to use it to travel to the country from which you claimed asylum. It's recommended that you wait until you get your citizenship and then you may consider traveling to that country. After you talk to an immigration attorney, of course, things like that have to be discussed with an immigration attorney ahead of time, ahead of the travel. You can also apply for an advance parole, which is a travel document. It's a regular travel document that is issued to people who apply for adjustment of status. But a huge difference between the refugee travel document and an advance parole is that the refugee travel document usually has longer validity date. It also may allow people who have this refugee travel document to travel to certain countries without having a visa. This will need to be double checked with every specific country you will be traveling to. But I do know that at least 2 years ago, people who received refugee travel document were able to travel to Germany without having a German visa. So if you have an advance parole would not give you those privileges. Also, advance parole is a piece of paper, and a refugee travel document looks more like a passport. A lot of refugees do not, or SLEs do not have their passports. They can't really go to the embassy of their country to request a new passport. So, having a refugee travel document is a huge advantage for those people. It will have all their personal information, just like a passport has. It can be used as an identification document, as a travel document. So, definitely, if you're a refugee or an asylee, I would recommend filing for a refugee travel document with the adjustment of status application. Another question I received is from one of our followers who was asked by a friend of his to testify in immigration court as to the good moral character of the applicant. Is it safe to do that? My immigration status is an adjustment of status applicant in the United States based on the grant of asylum in the US 2.5 years ago. So if you were granted asylum in the US, you're applying for an adjustment of status in the US. If the immigration judge allows you to come in to the individual hearing and support your friend who is in removal proceedings and testify in terms of the good moral character of this person, and you're sure that this person is a person of good moral character, you do know this person personally, then I would say it would be safe to testify in the immigration court. You don't have to say anything about this person's asylum case. Asylum is strictly confidential, and I would not recommend to testify about anything else besides the good moral character and things that you personally know about this particular applicant who's a friend of yours. You also don't have to disclose the fact that you have applied for asylum some years ago. Asylum, like I said, is a confidential process. So the judge will not be asking you about your asylum case that was already closed in the immigration court if you won your asylum. The A number is another piece of information that you are not absolutely required to provide. If you don't want to provide your A number, you may say so, and then it will be up to the immigration judge to see if you will be allowed to testify in terms of the good moral character in the immigration court. All right, I'm going to see if we have any questions on Instagram. All right, let me double check our Instagram account for any potential questions. I don't see any questions on Instagram. So I think that concludes our first Friday, and I hope your summer has been going well. We are back with our first Fridays, and we will see you next month in September. Have a very nice weekend and enjoy the rest of the summer. Bye.